that they're not enrolled in on the activities of each subcommittee. So with that, I'm teaching today at 11. So in the event that we go past 11, Professor Kammer will be officially the chair for the remainder of the meeting. Thank you, Professor Kammer. And I think our line item, the first one is going to be remedies. I don't know if Lucas or Josh who's presenting, but we'll turn it over to you guys.
All right. Good morning, everybody. So I did not prepare a fancy PowerPoint today, but just some updates on remedies. Just kind of to sort of circle back and recap for everybody. Remedies had split our topics into really three main buckets, as we call them in our group. The first one was the permanency issue. And so we finished that one actually back in May. We then moved on to the preponderance of the evidence, which we have now concluded, and I'll give our updates on that. And then we're now working on kind of the underlying process and the interplay between expungements, the appeal process, kind of the sort of nuts and bolts, if you will, of when somebody actually goes through the disqualification process. So that's our biggest one, and we're planning to spend some time on that. But as far as the preponderance of the evidence, our group really looked at and compared Minnesota statute to what the federal requirements are for disqualifications, as well as other states really surrounding Minnesota, just to sort of see what seems to be there and try to get some feedback from other outside groups, not just, of course, individuals in our group. And so we really, after all of that research and after talking to additional individuals, really came to the conclusion that a recommendation should be made that disqualifications will no longer be made on a preponderance of the evidence standard. It was really clear that Minnesota is an outlier in that. And I think when we look at, I guess, as somebody who practices in the criminal world, there could be a variety of reasons why a case may be dismissed, or there may be no plea that's actually entered, or just maybe charges were never even filed. And so to use that preponderance of the evidence as a means to disqualify just brings in, I think, sort of does not recognize even the purpose of many of the criminal statutes as to why cases are dismissed or dispositions are reached. And so from our view, that should not be something that should be included. So going forward, the recommendation would be disqualifications would only be made for convictions or where there is that formal judicial determination. So for example, stays of adjudication. And then, so that was based on all of our review and discussions, that was one piece that we reached. The other piece that we reached is because disqualifications are also made based on serious or reoccurring maltreatment. And so we really looked at our maltreatment statute, how that process actually works, as that is technically based on a preponderance of the evidence. And I think as a practitioner who practices in those maltreatment areas, I had some concerns for simply using that maltreatment as an underlying basis to just simply disqualify someone without more due process. I voiced concerns in our remedies subgroup as to issues that I have seen and how those are used, and even just sometimes what even goes into them, into the determinations. And while I think that's in line with the maltreatment statute, I guess I disagree some of it, but we felt that there should really be more, especially when we're looking at this is somebody's ability to earn a livelihood, essentially having some additional fallbacks and some additional protections on the disqualification side. And so what we really talked about would be that disqualifications would be based on a serious or recurring maltreatment would actually be made on a clear and convincing standard, We also are recommending that family assessments will not be used to calculate whether maltreatment is reoccurring. One of the basis for that, just to highlight for the group, is whenever an allegation comes into child protection, it can go either an investigation route or a family assessment route. Family assessments are not appealable. And so the concern would be that if a family assessment, what was gathered during a family assessment is used to make that determination of serious or reoccurring, that's bringing in an allegation that somebody never actually really had the chance to litigate or to really have any due process on. And then we are also making the recommendation that hearings are always available for disqualifications based on serious or reoccurring maltreatment, even if the individual did not appeal the maltreatment at the local level. And I think the concern that arose out of that is looking at the maltreatment letters. Individuals are not often told the effect that it can have. I think there's, again, some due process issues with that. I guess it'd actually be more of a notice issue. And then at the hearing, the department would have to prove the maltreatment by clear and convincing, and that the individual can still challenge it at the appeal process, even if it was upheld as a preponderance of the evidence. And I'm happy to, I don't know that I was planning for it today, but I had done a presentation just to highlight some of the issues that I see when litigating the maltreatments, and sort of the ease with which some of them are dismissed, as well as just, again, I think the lack of notice to individuals when they receive the letter as to really the consequences that can come from it, and the impact that it can have. So I think really the goal, we weren't charged to look at the maltreatment statute, but when it does have that interplay with disqualification, we really felt that ensuring due process was important when we're looking at somebody's livelihood and really the availability for the workforce. So that's what I got.
Any questions for remedies based on that? And I'll defer to you, Ms. Dawson, to call on people as you see fit.
Yep. I see Representative Moeller has her hands up.
Yeah, thank you. So I was wondering, for when you were talking about the preponderance standard and eliminating that, I'm trying to remember what we looked at as far as data, and what kinds of cases those preponderance cases are mostly happening in. Are they happening frequently in domestic assault cases, child abuse or child sexual assault cases? I guess that's the first part of my question.
Yep. So we did look at that. So I'm going to speak a little bit off the cuff here because I don't have that specifically, the numbers right here. So I guess take what I'm about to say with a little bit of a grain of salt. Is that I think where we saw the largest numbers of the preponderance of the evidence were in the misdemeanor category. And I will tell you, and I'll be upfront, the largest number were on the domestic assaults. And so those were where I think they were using whether there was a charge that was later dismissed or a continuance for dismissal or something like that. That's really where that was, which we factored in. But again, I think there was quite a bit of discussion surrounding that. And I see, is your hand still up?
It is, yeah. And I guess I'll just say that somewhat gives me pause, just because those cases, as a prosecutor, I see folks who have a whole host of charges of domestic assault, and being able to prove that beyond a reasonable doubt, especially if you've got a victim who isn't going to come to court, is incredibly difficult. And so, there are people for whom I am pretty certain have many, many domestic assaults, but they don't have a conviction. And so I guess I'll just say for those cases that eliminating the preponderance standard, or even if it was changed, I don't know if you talked about making that one a clear and convincing standard. I certainly understand the problems with the preponderance standard, but I just want to kind of flag the domestic assault cases cause me concern.
Yep, and we did seek some guidance from, for example, Max Page on that one as the representative from the County Attorneys Association. And so our actually recommendation really comes after speaking with him, and that I understand there can be, from the prosecutor's side, maybe an uncooperative victim or something of that nature. However, I think we also looked at it from the standpoint of that's often within the intimate relationship, and we're looking at do those individuals also have issues outside, in their actual employment realm, along with, I guess, is from the defense side as well, often seeing it where our statutes charge not only the harm, but also simply the fear of harm. And so it is bringing in more. And I think it also is contrary to many counties where there's a diversion offer and a continuance for dismissal offer, with the whole point that it's not on somebody's record. And the whole point that then that person is allowed to go through and work and have that life. And I think so, to have it from the preponderance of the evidence standard. And that's why we're keeping the compromise, partially was also to keep it where is that admission. And so we've got that stay of adjudication or the conviction. And so I think it's trying to balance all of that. And I see Josh has his hand up.
I was just going to point out the stay of adjudication compromise too. And just sort of anecdotally, I practice a lot in Hennepin County, and the city of Minneapolis uses stays of adjudication on domestics pretty regularly. On those misdemeanor domestics, which is because I also I don't think the domestics stood out as much among felonies. Like felony domestics didn't depart as much from other felonies, if I recall. I could be wrong on that. If I am wrong on that, Mr. Vogel, please correct me. But I think the case representative, the fact pattern representative Mueller that you rightly point out is really with those misdemeanor domestics. And so I would just add that stays of adjudication are a common disposition on those with prosecutors in Minneapolis that are seeking to find that balance between heading off all of the collateral consequences of a really stigmatizing conviction while still, getting that finding on the record and accountability.
Anybody else?
Would it be helpful, do you think, Ms. Dawson, to have the data analysis subcommittee put together some numbers on the preponderance of evidence and how they all break down in alignment with Representative Mueller's question?
Yeah, I think that's fine. I do know, yeah, I think that's fine just for people to see to be frank, I don't think the preponderance of the evidence is for sure not the largest number. And so, but yeah, I think that makes sense from that standpoint.
And, one thing I wanted to say, and this is anecdotally too, is that the process at the department has always been frustrating to me as an advocate, because an individual will be disqualified on a preponderance of evidence. So they've never had a hearing oftentimes on that issue. And then by the time they get an appeal in, it gets heard by an ALJ, it could be 9 months have passed before they can kind of undo it. And that's a lot of damage in 9 months. And the department historically has not interviewed anybody. They've just sort of taken the paper record, and it's a paper review. So those have been some of my frustrations, but that again is me. Anybody else with questions for remedies? Okay, we're going to move on. I guess I'm next with the disqualification. I wouldn't say I put together a great PowerPoint, Lucas, but I did put one together to kind of help my thoughts. And there it is. It actually looks completely different than I thought it was going to look, but I'll take it. So disqualification subcommittee, if we can, I guess you're in charge, Will, if you could move me along. Here's our update. really one of the things we've been focusing on is the structure of disqualifications under the Background Studies Act. And as we talked about a lot, but we want to make sure other individuals who might be streaming this or watching it later understand that our current structure for disqualifications is 4-tiered: permanent disqualifications, which are going to be pretty serious matters. These disqualifications never expire. 15-year disqualifications for felonies, 10-year disqualifications for identified gross misdemeanors, and the 7-year disqualification for misdemeanors and those civil maltreatment cases, which would be maltreatment to minors and maltreatment of vulnerable adults. So this has been what we've been looking at most recently, is this structure. If you can go to the next slide. So we identified as a group some problems that we thought with this structure, that the disqualification periods tend to be longer than are necessary for many of these matters to maintain public safety, and that this is not a punitive statute. This is a statute designed to ensure the safety of vulnerable populations, and that maybe this is too long as necessary. It's inconsistent with other states in that it tends to be significantly more kind of punitive in nature, that the crimes, we have more crimes listed and significantly longer disqualification periods. The structure oftentimes exceeds the federal mandates, which are admittedly sort of the minimum for some funding, but and we'll get to this more about the Adam Walsh Act and others, that ours structure is, again, exceeds that. One of the difficulties is that for conviction cases, the disqualification period doesn't begin until an individual's off probation or court supervision, which does extend a disqualification period. One example would be a felony case with 5 years probation essentially becomes a 20-year disqualifications, because you have to add the 5 years to the 15. The 15-year clock does not begin to tick until a person is off court supervision. And the list includes some offenses that just don't have a bearing on public safety. There's some drug possession cases or other property offenses, some of them being 15-year disqualifications. And our current law removes, and this goes to Mr. Urban's point that he's made, I thought eloquently at times, that the law removes the employer from making any informed decisions about hiring somebody. And a disqualification is a disqualification. It's actually a crime for an employer to violate it and hire somebody that the departments have determined is disqualifying, which is unique and is not like most other professions. Go to the next slide. So we just wanted to address this is some things we're not looking at, and Ms. Dawson's already identified this. We're not looking at the preponderance of evidence. We're not weighing in on that now. We're not weighing in on whether a permanent disqualification should be eligible for a set aside. All of that stuff, whether there's going to be an extra waiting period. I don't know if anyone else in the DQ subcommittee has anything to add, but just identifying also what we're not looking at, because we're trying to stay in our lane and give this to remedies. So one of the possibilities we came up with, and this is again just in terms of structure, is to eliminate the 4-tier structure and come up with a more simplified 2-tier structure. That disqualifying offenses would either be a permanent disqualification or a 5-year disqualification. And we looked at a lot of different things, and the reason we came up with that is it's consistent with the Adam Walsh Act. It's not going to interfere with funding that's connected with it. It is simple, which I think is easier to administer, easier to explain, easier to follow. I think easier for individuals who work in criminal justice defense and prosecution can explain it more simply, and it can maintain public safety without an overly restricting individuals from their chosen employment, licensure, volunteering, etc. One of the things, we don't know yet, or doesn't have to be, is always want thoughts from the group as a whole. Is 5 years the right amount of time? And so maybe at the end of this, we'll open that up to anyone who has a thought, but this is the first possibility that we have for a recommendation moving forward, simplifying and 2 tiers. If you go to the next slide, Will, that'd be great. So the questions we really have moving forward, and some of the hard work now, is going through all the 4 tiered lists of crimes and figuring out as a recommendation what stays as a permanent disqualification, what doesn't. You know, we have in our background study act more offenses than are included in the Adam Walsh Act. I know that failure to register as a predatory offender is in there. There's some assaults that are in there. And when I say in there, are currently in our permanent list of disqualifications that are not in the Adam Walsh Act. So a lot of this is some heavy lifting and figuring out where do offenses go, you know, regardless of level. Do they fit into the 5-year disqualification or permanent disqualification? And once we do that work, does it make sense? Have we achieved something that balances public safety versus employees having the opportunity to work and employers having more of an opportunity to hire, because we're dealing with such huge shortages? Another one of the issues we have to determine is when these disqualification periods begin. And so we talked before about, you know, sometimes with the felony cases, a 15-year disqualification is really a 20-year disqualification. What should the date be? Should be the date of the offense, date of conviction, release from supervision. I know Mr. Page had identified something they had come up with, I think, for the child foster care rules, was if it was a case that involved any kind of incarceration, it would begin the date of release from incarceration. But if it's a conviction where there's a probationary period, it might begin at the date of conviction. A lot of people like the idea of conviction because the date's pretty easy to find. Date offense can be a little bit problematic, both with identifying it, and certainly some cases aren't able to be prosecuted at the exact date of the offense. A lot of reasons for that. And one of the issues moving forward, and I think this is again more remedies, is with these permanent disqualifications, if we move forward with this model, would those ever be eligible for a set aside? Doesn't mean they'd be eligible immediately. Is there an eligibility thing that after 10 years you could seek it? As we all know, currently there are no set asides for just permanent disqualifications. And if we set up a system that has a permanent list, are there remedies available? And so I think this is going to require some synthesis with remedies. If we have this recommendation moving forward, is what would be the set aside availability? I think we have one more slide, Will. So yeah, we're just continuing to review this rather long list and trying to figure out where they fit in. Sometimes when we talk about these, we don't have unanimous consent, and continue to look at data to support, you know, where these cases should remain. And after we finish that, we'll bring it back to the group as a whole. But some of the other things we're looking at, and Ms. Sherlock and Ms. Kaser will be leading us in a child foster care analysis, specifically related to disqualifications and that license, and whether or not this structure should be broken down more to have certain professions sort of removed and have a different set of disqualifications. One that had been identified are the drug and alcohol counselors, being in a different, dealing with a different vulnerable population than, let's say, nursing home patients or children, that there is something different intrinsically about that work that maybe we should have, like we have for child foster care, just a little bit of a separate structure. That makes things a little bit more complicated, but might make more sense in the long run for those professions. That's what I've got. Will, thank you. Any questions from anybody? Nailed it. Perfection. I love it. I'm amazed. Great. Why don't we then move on to our next group, which would be, I believe it would be the data analysis group, and then we will finish with just data. So Professor Cameron, please.
Well, sure. Yeah, we have a PowerPoint to share as well. We've had a few meetings and have crunched some numbers and had some discussions about the best way to display it. So I'll share that with you in just a moment. I have to give a big thank you to Will. Whenever we get data from DHS, he always puts it into a spreadsheet for us. So it makes it a whole lot easier for us to calculate some percentages and such. So just a big thank you there. So with that, I am going to go ahead and share my screen. And it should look a little something like this. We always keep them simple because our goal is to have them presented in a way that if you need to grab them or something, it's not highly formatted. It's just the data, and I will give some narrative as best as I can as we go along. But this all comes from data set 4. As you'll probably recall, last time we presented, we took a look at some limited data from data set 4, where we looked at basically by race, those that were considered eligible to work based on our collapse categories. Well, we went back and we've taken a deeper look at data set 4. We requested some additional data from DHS. We just got it earlier this week and have some, very new data to show you here. So I'll walk you through. So this is something that our group worked on a couple weeks ago, and we haven't had a chance to show it to the whole task force yet. But we looked at overall looking at reconsiderations. We wanted to see by gender and by race who was actually making requests. But just to set the stage, in 2018, when you look at reconsiderations requested, what you can see here is, 62% of individuals who would be eligible to request reconsideration did not, and 38% of those individuals did request reconsideration. So what I want to do here is take a look at gender. And what our data analysis subcommittee decided to do is actually take a couple steps back here, just to paint again this really full picture of big level down to the most micro level we have. So looking in 2018, when you think of overall determinations made, those people submitting for determinations, and these again are distinct determinations. These are not necessarily individuals, but this is the number of determinations by gender. 75% were female, 25% were male. Now you can draw your own, conclusions, hypotheses here. We're not able to give the reason why, but obviously we have more females having determinations made than males made, and that could be just workforce demand. We don't know, but we'll leave the data where the data are at. Then we'll go down to that next level. So when you think of once a determination is made, well, how many of those individuals are disqualified? Well, when we look at disqualifications, and again, I shouldn't say individuals, I should say these are just total disqualifications, and sometimes individuals are having multiple, studies, or I shouldn't say studies, but determinations made. So these are unique disqualifications, not unique individuals. But 66% were female, 34% were male. So even though females make up a larger percentage of determinations made, ultimately lower percentage of females are ultimately being disqualified. And then on that far right there, what I want to draw out is this is percentage-wise reconsiderations requested. And what we see here is 72% of the reconsiderations requested were for females and only 28% for males. I will show you here in just a moment. We did the same thing for 2019, and things look relatively similar there. The other thing we did is we kind of jumped ahead in our prior presentation and displayed for you actual eligibility to work based on reconsideration request by race, ethnicity. But we took a step back here and just looked to see by race and ethnicity, who's actually requesting reconsideration and who's not. So one of the things here, and this is where we see disparity again, which is, pretty prominent, is for white individuals. We're seeing, 45% of white individuals requesting reconsideration. We'd hope to see similarity for each race ethnicity category, but we don't. What we see is, 31% African American, 31% Asian American, Pacific Islander requesting reconsideration. And then most concerning here, this low amount for individuals identifying as Native American, only 22% are requesting reconsideration. So that's pretty significant. Again, we don't have the why, we don't have the explanation, but what we can say here is, looking at the data, there's definitely some disparity there. I'll scroll ahead, and this is 2019 data. So again, what you'll see is things hold fairly true here. Numbers are much larger, the N is much larger, but general percentages stayed pretty consistent looking at 2019. So this again is just overall count of, did a person, or how many reconsideration requests were there and how many were not requesting reconsideration. We again did the breakdown by gender, starting at the very high level and going all the way down to reconsideration requests. And I'll show you 2019 here, and I'll scroll back to 2018. So hold that in your mind. Not a significant change there. Things are looking pretty similar. And then here again, when we look at reconsideration requests by race ethnicity, what we can see is, the race with the highest percent, the highest likelihood to request reconsideration would be white individuals, followed by African American and Asian American, Pacific Islanders. And then the race identified that would be least likely to request reconsideration would be Native American individuals. So that's what we have by race there. We will go ahead and insert in those prior slides where we talk about actual eligibility determination for race ethnicity. We just haven't gotten there yet. So our most recent endeavor into data, we did a little more work with reconsideration outcome. And one of the things we're getting requests for is, well, tell us about, who's more likely to get a determination to be eligible to work? 7-year disqualifications, 10-year, 15-year. So that's where we're going with this data. So just to give you the overall, this is 2018 on the left, 2019 on the right. What we can tell you is in 2018, of those individuals who requested reconsideration, 74% were determined eligible to work and 26% were determined ineligible to work. We have those in quotation marks because it's not an official term. It's something we did in working with DHS to collapse all of the different categories of eligible to work versus not eligible to work. So they're collapsed categories. What was interesting in looking in 2019, we saw a little bit of a shift here. So we only saw 2/3 of those individuals who were requesting reconsiderations being determined eligible to work, and of course, 1/3 being ineligible to work as a result of their reconsideration. So we took it a step further and we said, let's look at this by, that look back period. Let's take a look at 7-year versus 10-year versus 15-year and, see how it looks. And what you can see here is there's some difference. Ultimately, when we take a look over on that far right side at the 15-year disqualifications in 2018, you can see that there are is a little bit higher percentage of percentage of cases where the determinations are ineligible to work. For the 10-year and the 7-year, both at 23% for ineligibility determinations. Want to just make a note here, we excluded 10-year bar, permanent bar, and years disqualifying not entered for offense. So those aren't reflected here. We just ultimately looked at, these 3 disqualification periods. There also were the very small number of in-process requests for reconsideration that were still out there. We left those out as well. So this is just, really what we thought was the most pertinent information to take a look at. So this is 2018. So I want you to just kind of burn these images into your mind, what they look like. And I'm going to switch here to 2019 and just have you take a look at 2019. So here's again 2019. I'll pretend to be an optometrist here. 2019, 2018, 2018, 2019. You'll see a little bit of a shift here. And, one of the things that we were really most curious about as a subcommittee is looking at those shifts in ineligibility as a result of going through the reconsideration process. What you can see is there was a fairly big shift in the 7 years. So in 2018, 23% were ineligible to work as a result of the reconsideration process. In 2019, it jumped up to 33%. Over here on the far right side in 2018, 30% for ineligible and 34%, so a little bump in 2019. So what we've been working on, and we're not completely done yet, this is a work in progress, is we started to take a look at, doing a little bit deeper analysis of these reconsiderations. So just to break down what we did here, just to make a little sense of it, left hand is blue, right hand is orange. The left hand is 2018. The orange on the right is 2019. What we did is we took a look at the top 10 per se, whenever we could, the top 10 reconsideration requests by crime conduct type. So what you can see here is in 2018, the most frequent type would be theft. There were 482, and that's 31% of the overall total there. So it's a big number of the requests for reconsideration coming in are for theft, and so big percentage right there. Determined eligible to work, well, 353 of those 482 were determined eligible to work, which is a 73% success rate. As you keep in mind, we saw kind of a big shift from 2018 to 2019 in eligible to work determinations based on reconsideration request. Well, a lot of it has to do with this top category. Theft was top for 2019 as well. And what we saw there, again, these are bigger numbers, but we'll take a look at percentages, 36% of the total. But it was 821 was the full number. Again, 519 were determined eligible, but that's only a 63% eligible to work determination based on reconsideration request. And since that's such a large percentage, that's really what is responsible for that big shift in the number. That's what it would be, what we'd say most attributable to. We did the same for 2000 for the 10-year disqualifications. I'll note here the table on the left is a little shorter than the table on the right. That's just because we couldn't do a top 10 because all the remaining categories were less than 10. So this just lays out for you again, who's requesting, who is requesting reconsideration? What are the crimes, the conduct most likely to request reconsideration? And that's ultimately what these display. We didn't have time to get to the 15-year disqualification analysis. We will do that next. So that is what I have to share on behalf of our committee. I hope it's helpful to you in some way, shape, or form. But with that, would love to answer any questions or see if there are some spots you'd like us to dig a little deeper, or maybe you have some suggestions on how we might display the data a little bit differently just to make it more useful to you. So with that, I will be quiet.
First of all, thank you so much. I find that so much easier to look at. Will, I love your work on spreadsheets too, but I find it much more digestible when Roy comes in with the charts. Any thoughts or questions for data analysis and Professor Kammer? Okay, another home run, Professor. So thank you. Why don't we?
I don't have any questions. I just wanted to echo my thanks. I find that data really helpful, and we're using it in our remedy subcommittee meeting. So appreciate you.
Agreed, 100%. Thank you, Josh. Why don't we go to Chair Williamson and get an update on data? Chair Williamson, happy Friday.
Happy Friday, Chair. And just so ecstatic about all of the developments as we are really gearing at our recommendations as a task force. I just wanted to share that I know with the data subcommittee, there has been, it was another request that we were able to get in writing, and Mr. Vogel submitted to DHS. We also had some questions that we needed expedient answers to that I'm happy to report that DHS was able to provide. And so we're just on the ready in regards to, as we're taking these deeper dives, to continue to submit those formal requests.
Thank you so much, Chair Williamson. And are there any questions for the data subcommittee, or maybe even more specifically, requests that you would like the data subcommittee to pursue? Okay. Thank you, Chair Williamson.
I'd like to add a big thank you to DHS. Chair Williamson talked about the most recent request. These last few slides I presented were that most recent request, and DHS was super fast on getting us the data. So we were so just ecstatic to have it. We were able to look at it this week. So thank you, DHS, for making that happen. And thank you, Chair Williamson, for helping us to get that data we needed.
I think that's a great point, Professor Kammer and Inspector Mahody. Thank you, and the rest of you guys don't get enough credit. we like to point out faults, but don't do a good enough job of identifying all the really important and helpful work you do. So thank you. I echo Professor Kammer's thoughts.
We appreciate that, and know that's a part of our work. But we have I just want to shout out to my data team, and there's lots of people on the data team that are working on this, and legal and our background studies division. So working really hard to be able to get things to you all timely. Sometimes our timely and your timely are different, but just we're working on it, and so we're really excited about this. The task force and where things are going, and the looks that you're taking on it, and so we do appreciate it. So thank you.
Thank you so much, Inspector Mahody. I like that you sent a shout out. You don't hear DHS give many shout outs. I like the vernacular. Mr. Vogel, do we have anything else? I don't have anything else listed for today. Is there anything else that you have?
I don't believe so, Mr. Chair.
Okay. And then let me open it up. If anybody has any questions, concerns, or issues that the subcommittee should embrace prior to our next meeting next month. All right, seeing nobody else, we are an efficient group today, and we'll sign off and we'll adjourn. I want to thank everybody for their time, and especially all the amazing work people are doing in the subcommittees. We will see everybody in your subcommittees, and have a good day.